Friends, welcome to DK Management HR and Labor Laws Advisor YouTube channel. In our earlier video, we had discussed about workman, employer, establishment, the Industrial Employment Standing Orders Act, its applicability, and we had also discussed about the workman status and their terms and conditions. We had also discussed who is workman, who is not workman. So, appointment letter is binding document on employer's part. This is also a common and legal document for both the parties. They must preserve this document on permanent basis, original record. If they misplace, either party is likely to face the problems if there any arises, difference between or conflict between the parties. So, let's go to the model appointment letter. We can call it as an ideal appointment letter also. But initially, I am giving you the legal and model appointment letter for the workman because that is the major part in the organization, and all the labor laws applicable to workman category. So let's go to the appointment letter, and it's the important point. This appointment letter has to be on company letterhead, that too in duplicate, because I will explain you in details. As you know, appointment letter is issued normally after process of completion of employment application, interview, salary negotiation, and all the positions, etc. Once we conclude this part, then at the time of joining, company has to issue this appointment letter to the respective workman along with all the applicable details so that there is no confusion as such. So as we see, normally it is addressed to the workman with full address. Date of issue is also must. Then subject. Then first para is about the reference of application and employment interview. Then next point is about probation period. This probation period or all the terms and conditions of the appointment letter I have mentioned here, they are based on the Maharashtra's model standing orders. So in Maharashtra, under model standing orders, probation period is 3 months, and in case of performance not satisfactory, then management can increase it further 3 months probation period. But we had observed in the market in general, most of the establishment follows the 6-month probation period, and many times they also extend the 6 months also. So it violates legal requirements and it can also invite the problems to the management. So be careful before issuing and designing these appointment letters, employment terms and conditions. It is important that during the probation period also, one has to perform the normal duties with required skills. After satisfactory completion of the probation period, company can issue confirmation letter. But normally it is a misconception in the market. It is mentioned like this: unless confirmed in writing, workman will be deemed as probationer after expiry of the initial period of probation, and they delay the confirmation. That is not advisable. During the probation period, either party can discontinue or terminate the services by giving 7 days notice. After confirmation of the services, as per the model standing orders, either party has to give 15 days notice. If they fail, there is a process, judicial process laid down under the Act. If workman fails to serve this notice, company is authorized to prosecute the respective workman. At the same time, workman has to give 7 days notice, or it may invite some problem because workman is assigned some specific responsibility. But after confirmation, if somebody resigns by giving 15 days notice, company has a right to either accept immediately or waive the notice period also. Company can also reduce the notice period also. In specific cases, depends on the exigencies of the matter. Again, this is more important. During the notice period, if some confirmed workman is resigning, workman has to serve physically during the notice period, because it is very clear. Somebody is confirmed in the services means workman has been given the confirmed responsibility. So if workman leaves abruptly, it may invite problems to the organization. So many times company doesn't allow any leave or any special absence from the duty. In the appointment letter, company has to also mention the compensation as discussed and agreed between the party. But before giving the breakup of these wages, there are 3 legal factors applicable in Maharashtra subject to certain rules and regulations. So, first is basic wages, second one special allowance, its nature is parallel DA, or human resource allowance, house rent allowance. After that, it has to be also clarified to the workman in the appointment letter whether the respective workman is eligible for PF, ESI, bonus or any other legal membership or voluntary membership. Management can also reserve their rights to alter their appointment letter or modify the appointment letter and wages, compensations, facilities according to the changes in rules and regulation as applicable to the organization. It is also expected and mentioned in the appointment letter, whatever the work is assigned to the workman has to maintain the secrecy of the business of the organization. Otherwise, it may violate the rules and regulations. It is very important to see at the time of joining the organization, respective workman is physically fit and company has right to get it certified from the authorized or company's doctor. During the service, respective workman has to be very punctual, serious and delivers all the rules and regulations and requirements of the organization. You shall also inform the management in case you observe any of the mishaps or wrong things or dishonesty, fraud like this matters to the management immediately, if possible with satisfactory proofs or evidence also. Normally, it is mentioned in the standing orders that all such communication shall be in local language. But English being the business language, most of the companies follows the English language, and if it is essential or demanded by the workman to give the translation of such communication in local language, company is authorized or binding to provide such communication in local language also. Disciplinary action or misconduct or its a process is also laid down in the model standing orders. So just to highlight, companies also mentions in this that any communication which is official or business related worker has to accept it. If they refuse it, it can term as misconduct and company can take appropriate action also. Similarly, it is important to mention in the appointment letter what way company is likely to communicate to the workman. So, please note, majority of the companies doesn't accept SMS or WhatsApp or email or any other soft format communication, and it is not accepted. We have discussed if lawful and reasonable order, if you refuse, company has a right to take the appropriate action. You are also entitled for wages only when you deliver the 8 hours honestly duty, because your compensation is decided for the daily 8 hours output or productivity. Next point is very important, annual increment. Many times it is misconcept in the minds of the workmen or parties that annual increments there is their right. No. Annual increment is granted if somebody's performance average or satisfactory. If somebody's performance is not satisfactory, then companies are authorized to hold the increment, and if somebody's performance is really excellent, companies can reward by different ways also. You have to also report your duties on time and leave your duties on time. You are not supposed to waste your time during the 8 hours. So that is also important. If you violate that, you are also liable for the appropriate disciplinary actions. It is one of the important clause now about the transfer of the services. Companies also mentions the workman's transfer if situation warrants to any of their department, section or group company or any other factory, establishment or subsidiary at anywhere in India. You are also must be available for the alternative work. In case of any exigencies, it is required for the organization to offer you some other alternative work. You cannot refuse, otherwise it's a misconduct. Company has to also attach job profile along with your appointment letter. Once the job profile is given, both the parties are very clear about the duties of the workman, at the same time what he is supposed to or she is supposed to deliver to the organization and what organization can expect. At the same time, many companies work in shift, so it is binding on workmen to work in various shifts. As I just mentioned about the general misconduct, it's a big list in the model standing orders, but one specific act is recently introduced in India. So companies also mention about that act, and that is the Prevention of Sexual Harassment Act at the workplace. They are also highlights all the details in their appointment letters. Next point is very clear. Your interview is always based on your employment details. So, based on that process, your appointment and all the employment terms and conditions are decided. So, if organization observes any time that particular information given by you is false or misleading or correct, error with having error, then it is very serious. So your services can be discontinued immediately without any notice or compensation during such occasions. At the same time, management can also recover the payment made to you towards wages during the employment and likely to prosecute appropriately in appropriate judiciaries. It is important to follow the safety and health guidelines also, because it is must for the self also must for the co-workers and organization to maintain the discipline and environment. Retirement age is very important factor. Because of the retirement age, many times there are confusions. So company also has to mention about the retirement age. In such case, in Maharashtra, 58 years is given as retirement age as guideline. But because of certain essential requirements, companies can increase their retirement age, or if they want to reduce with either party's understanding, they can reduce the retirement age also. It is also important to mention in the appointment letter that all existing practices, terms and conditions of the employment must be continued, because most of the common practices and rules and regulations are applicable to other workmen also. We had discussed about 3 types of leaves. Earned leave, which is called privilege leave, casual leave and sick leave. Company has to mention the entitlement process in their policy and brief the respective workman. Because of certain exigencies, management is required to alter or modify the terms of employment conditions. So it is also mandatory on workman's part to accept it, because all those things lead to the business ultimately. Once this letter is fulfilled and complete, then from company side, some authorized person has to sign this letter. Then workman has to put the initials as an acceptance and mention that workman has read, understood the contents of appointment letter and employment terms and conditions. So, and put the initials. This is how appointment letter becomes ideal or model appointment letter. Please don't forget to subscribe our channel, comment, share and like also. Till then, see you in next video in next week with new topic. Stay home, stay safe. Goodbye. Thanks for watching our video.